All right, we're diving into what are, no joke, two of the most fascinating defenses in all of criminal law. We're talking about situations where that fundamental link between a person's mind and what their body does is just completely gone. It raises some really deep questions about responsibility.
I mean, just think about that for a second. Can you really be guilty of a crime you didn't even know was happening? If your conscious mind isn't driving the bus, so to speak, is it still your crime? This is the massive puzzle that the courts have to try and piece together.
So first up, we've got the mental disorder defense. This is laid out in Section 16 of Canada's Criminal Code. And look, this isn't just about someone having a mental health condition. It's a very specific legal test where the accused's entire state of mind, at that exact moment the act happened, is put under a microscope. Now, the most important phrase to latch onto here is disease of the mind. This is a legal term, not a medical one. The law isn't really concerned with a specific diagnosis from a doctor. It's focused on one thing. Was the person's mental state so impaired that they either couldn't understand what they were physically doing or they couldn't grasp that it was wrong?
So that begs the question, right? How did the courts even begin to figure out what legally qualifies as a disease of the mind? Well, the case that really set the foundation for all of this was R. v. Cooper.
In the Cooper case, the court decided to cast a really wide net. They basically said a disease of the mind could be almost any condition that messes with your mental functioning. But, and this is a huge but, they specifically excluded states you bring on yourself, like getting drunk or high, and also temporary states, like getting a concussion. They also added that the accused has to be able to fully appreciate not just the act, but all of its predictable consequences.
Okay, but what if someone totally understands what they're doing, they just don't feel bad about it at all? This is where the case of R. v. Keltson comes into play, and it carves out a really critical exception.
The court in Keltson drew a really sharp line in the sand here. They said this defense is about a lack of understanding, not a lack of feeling. The message was crystal clear. Not feeling remorse or guilt, even if it's because of a condition like psychopathy, doesn't get you off the hook if you knew what you were doing and knew it was wrong.
All right, so if that wasn't complicated enough, let's add another layer. What does it actually mean to know that something is wrong? The case of R. v. Oman really forced the court to get granular on this exact question.
And this is where things get really nuanced. See, Oman knew on an intellectual level that murder was wrong in general. But his paranoid delusions were so powerful, he genuinely believed this woman was part of a grand conspiracy to harm him. So the court decided, you know what? It's not enough to just know the rulebook. You have to have the rational ability to apply that rulebook to what you're doing right now. And Oman's solution made that totally impossible.
Okay, so we've talked about a diseased mind. Now let's pivot and talk about something different, an act that wasn't willed at all. And this brings us to our second big idea, the defense of automatism.
With automatism, the argument isn't that the mind is sick, but that it's basically offline. The body is moving, it's performing actions, but there's no conscious, voluntary thought behind it. It's like the mind-body connection has been temporarily snipped.
Now this is where things hit a huge fork in the road. If the automatism was caused by something internal, something the law considers a disease of the mind, then the case gets routed right back to that mental disorder framework we just talked about. But if the cause was external, like a sudden blow to the head or an extreme psychological shock, it's considered non-mental disorder automatism. And the result? A full acquittal. The stakes could not be higher. So you could imagine the position this puts a judge in. It's an incredibly difficult choice. How do you draw the line between an internal problem and an external trigger? How do you decide which path to send a case down when one path leads to ongoing court supervision and the other leads to the person walking free?
And that brings us to one of the most famous and frankly unbelievable cases in Canadian legal history, R. v. Parks, the case of the sleepwalking killer. It's a case that forced the Supreme Court to actually create a roadmap for judges facing this very dilemma. The facts of this case are just staggering. Kenneth Parks, while completely asleep, drove 23 kilometers, broke into his in-laws' house, and killed his mother-in-law, and he had zero memory of any of it. The court had this impossible question: was his sleepwalking a disease of the mind? In this specific, incredible instance, they said no, and Parks was acquitted.
So to make that call, the court in the Parks case essentially handed future judges a toolkit. It has two main tools. First, the internal cause theory. Does this condition come from inside the person's own makeup? And second, the continuing danger theory. Is this likely to happen again, posing a threat to the public? These are what lawyers call policy considerations, looking past the one event to the bigger picture of keeping people safe.
So the Parks decision gave judges the tools, but it was still kind of like having the parts to build something without the instruction manual. The big question was still hanging out there. How do you make sure these really powerful ideas are being applied the same way, fairly, in every single case?
Well, the answer to that came in the case of R.V. Stone. This is the landmark case that finally took those principles from Parks and built them into a formal, structured framework that every judge could follow.
The Stone framework is a nice, clean, two-step process. First, the judge acts as a gatekeeper. They look at all the evidence and decide if the claim of automatism is even plausible, if it has an air of reality. If it does, then they go to step 2. The judge acts as a classifier. As a matter of law, they figure out if it's mental disorder or non-mental disorder automatism, using a holistic approach that includes those big ideas from Parks.
So let's see how this framework actually works in a modern courtroom. A perfect example is the case of R.V. Ledecky, which dealt with a really rare condition called sexsomnia, where a person engages in sexual acts while they are fast asleep.
So here's exactly how the court used that framework. They took the internal cause factor and said, yep, sexsomnia is a sleep disorder. It comes from inside the person. Then they looked at the continuing danger factor and found that yes, the condition is chronic and could be a recurring danger. Since both factors pointed in the same direction, the conclusion was clear. This had to be treated as a disease of the mind. That meant mental disorder automatism was the only defense on the table.
So, as we start to pull this all together, it becomes really clear that both of these defenses exist right at this crossroads, this fundamental tension between two huge principles: trying to find justice for an individual who may not have been in control, and the absolute need to protect the public.
You know, at the end of the day, it all boils down to this one core distinction. The mental disorder defense is all about analyzing a mind that the law considers diseased. The automatism defense is about analyzing an act that was simply unwilled. It's a subtle difference on paper, but it leads to dramatically different outcomes in the real world.
And that leaves all of us with the big, messy, ultimate question, the one that judges have to wrestle with every single time one of these cases comes up. In the incredibly complex world of the human mind, where do you draw that line between compassion for a person and the safety of everyone else? There are just no easy answers.